In my last lecture, I spoke to you about Article 19, specifically in light of freedom to make associations and freedom of speech, including the right to information under the RTI Act. Today, we are going to continue with our series on Article 19 of the Indian Constitution in light of the right to work and freedom of movement within the territory of India. There are three facets of today's lecture. Firstly, the right to move freely throughout the territory of India. Secondly, the right to settle and reside in any part of territory of India. And lastly, the right to practice any profession or to carry on any occupation, trade, or business. What are the prominent rights that feature in this? Firstly, it is the right to move across the territory of India and also to choose your mode of transportation. Then comes the right to have any vocation or trade, business, or occupation, as well as the right to work and equality at workplace. This would include various facets like gender justice, as well as the right of equal pay for equal work, and the basic wages that are guaranteed to everyone. What we notice with Article 19 of the Constitution is that it governs the way of life for all the citizens. And it has influenced the concept of the welfare nation. And we see that it has influenced many legislations. We have the Minimum Wage Act, we have the Equal Pay Act, we have the POSH Act, which is the Prevention of Sexual Harassment at Workplace Act. And with respect to freedom of movement, we have seen reasonable restrictions being imposed in the recent times, especially on account of the pandemic, when we see suspension of various forms of public transport. Hence, in the current situation, we can really observe how Article 19 is affected. With this, let us discuss some reasonable restrictions. The Constitution itself embodies certain restrictions through Articles 19, 5, and 6 of the Constitution in the form of, when it comes to the right of residence and the right to travel, one must ensure the protection of scheduled tribes. Scheduled tribes are enlisted within the Constitution itself. Sometimes reasonable restrictions are also imposed when it comes to the rights of the general public. Fundamental rights are never absolute. The rights of one individual cannot impinge upon the right of another, let alone the right of the community. Hence, reasonable restrictions with respect to travel and residence can be imposed when it comes to the rights of the general public. Though we say that one has the right to carry on any trade and business, one must have technical qualifications to be able to carry on such trade or business, as envisaged in Article 19, Subclause 6. At the same time, this provision also provides for certain restrictions that can be imposed by the government when they have businesses carried on solely owned by government. In case of solely owned businesses by government, as well as when the majority of the funding for certain business and corporations comes from the government. I would give a recent example to see reasonable restrictions in the present times. Let us go back to the COVID situation, wherein we observe that for the protection of the general public, reasonable restrictions were imposed taking into consideration the extraordinary times. We see that people were not allowed to move out of their houses, and through various provisions and extraordinary measures that were imposed through the Disaster Management Act as well as the Epidemic Act, we see that transportation, the right to move freely, both were curtailed, keeping in mind the emergency situation where it was necessary to do so to protect the general public. When we talk about technical qualifications as a reasonable restrictions, we often see that any particular job post or any higher education form that we fill, there are often qualifications and the bare minimum criteria that are specified for these. This does not mean that a person who does not have this criteria will also be eligible for the job just because of Article 19(1)(g). Therefore, any necessary qualifications that are required or the minimum qualifications required are not considered contrary to the fundamental right. Let us look at certain case laws and understand the scope of Article 19. The first such case that we'll see today is Sri Sidwali Steels Limited versus State of Uttar Pradesh. This case speaks about who can file a writ petition for Article 19. The Supreme Court of India has held that it is only the citizen of the country that can file a writ petition under Article 19. Therefore, corporates are not allowed to file a petition under Article 19, as corporates and corporate houses would not fall within the category of citizen. Olga Tellis versus Bombay Municipal Corporation as a landmark judgment when it comes to freedom of work and the right to work. Various nuances of the Constitution were discussed by the Constitutional Bench, led by Honorable Justice O. Chinappa, and it was held that there can be no estoppel against the Constitution. While upholding the right of the payment dwellers to continue to reside and live in the huts and carry on the business of hawking, we see that Olga Tellis versus Bombay Municipal Corporation allowed and upheld the rights of the street hawkers. Just subsequently thereafter, in the case of Sodan Singh versus NDMC, 3 years thereafter, we see that right to work, though, is a part of the fundamental rights. And in fact, in the Olga Tellis case, we saw that fundamental rights and the directive principles of state policy were read together to create a balance of rights and duties. The right of the individual to seek employment and the duty of the state to provide reasonable opportunities for employment. However, in the case of Sodan Singh, we see that the Supreme Court has distinguished this particular set of facts from the Olga Tellis case, wherein it has been held that right to work is not an absolute right. And though hawkers have the right to work, they cannot choose where they will squat. And when it comes to public roads, they have the right to occupy them in a reasonable manner without causing disruption to the general public. And therefore, in this particular case, it was held that they need to be relocated. Sometimes reasonable restrictions have to be imposed, keeping in mind the economy of the country as well as the sudden demand on account of various uncontrollable factors, including weather conditions when it comes to agriculture. Often crop production fails and it leads to certain measures that need to be imposed, keeping in mind the demand. One such case we observe is Lakshmi Khansari versus State of Uttar Pradesh, wherein a notification issued under the sugarcane control order, wherein the crushers were stopped from producing the local product, that is Khansari, and instead there was emphasis on production of white sugar because that would have been cheaper and available to a larger section of the population. This particular order of the state of Uttar Pradesh was allowed by the Supreme Court, and it was held that this particular order was not contrary to Article 19, taking into consideration the need of the general public and the fact that white sugar, which would be cheaper, would lead to a better satiety value for the large demand. Similarly, in case of Bombay Hawkers versus Union of India, when the provisions of the Bombay Municipal Corporation Act were challenged on the ground that the authorities were conferred with the arbitrary power to grant or refuse license for hawkers on public streets, it was emphasized that though they have the opportunity to be heard, the final power to decide the scope of occupying the streets rests with the Bombay Municipal Corporation because, as stated earlier, the rights of one particular section of the society cannot impinge upon the others. Another case where the state policy was upheld is the state of Kerala versus Joseph Anthony, wherein the state of Kerala had imposed a ban on the use of mechanized fishing nets and mid-water trawlers in territorial waters. This particular law was enacted to ensure that poorer fishermen, as well as to protect the rights of the poorer fishermen, as well as to ensure that the fauna is not destroyed completely by arbitrary fishing. It is important to ensure that there is a balance between the economical aspects of technological advances and at the same time such advances which are only available to certain sections of fishermen should not lead to a disadvantageous situation for the other fishermen. Therefore, all these judgments, we can see that the judiciary has played the role of balancing between various state laws as well as the rights of individuals, considering that India is a country that follows the concept of the welfare nation, as well as India follows the concept of parents' patry, which means that it is the duty of the government to ensure the social welfare, economic welfare of all the citizens and not just particular sections of society. With this, we would move to the last section of this lecture on certain restrictions which were held to be contrary to law. As stated earlier, the rights of one cannot impinge upon the rights of the others, and Article 19 seeks to regulate the way of life. How does one do so? When we see the case of Chintaman Rao versus State of Madhya Pradesh, the Honorable Apex Court has held that when it comes to the rights of BD workers, the act of the state government to arbitrarily stop BD workers from working during the agricultural season is contrary to Article 19(1)(g), because the right to work cannot be subjected to agricultural seasons and they would be allowed to continue to make BDs despite the harvesting season. Slaughterhouses provides employment to a vast majority of people in India, and the sudden regulation of slaughterhouses, wherein there was a ban imposed on the slaughter of cows and bulls, was held to be contrary to the right of various individuals. Mohammed Farooq versus State of MP is the case in this particular subject matter, and the Supreme Court has observed that though the slaughter of bulls and cows affects religious sentiments, that is not reason enough to arbitrarily impose a ban which leads to various people becoming jobless suddenly. And therefore, slaughterhouses were allowed to continue functioning in this present matter. An interesting facet of Article 19(1)(g) has been discussed in the case of XLY versus Union of India, wherein the Apex Court held that the right to work includes the right to close down a business. In this particular case, the petitioner wanted to shut their business, but the Factories Act did not allow them to do so. And that particular provision of the state amendment was held to be contrary to law. Therefore, to conclude, I would like to recapitulate the entire gamut of rights provided under Article 19. Article 19 provides for the right to information, the role of media houses in ensuring that the dissemination of information takes place in a systematic, pragmatic, and correct manner. Right of information includes the right to know, and that is why the RTI Act is of particular significance. Thereafter, we have the right to seek shelter, and also we have the right to move freely within the territory of India. However, reasonable restrictions are imposed on these rights in the form of certain situations in the light of national interest and also keeping in mind India's relationship with its neighboring countries. Thereafter, we come to the right to practice business and vocation. However, the same can only be done keeping in mind the best interests of the nation, be it in terms of economic and social policies. These rights are changing because of the changing scenario that our country is in and the changing economic facets that our country is in. I say this because as a developing nation, our rights and liabilities continue to change when it comes to a relationship within the country as well as with our bilateral partners. Not only is the pandemic one such example, another such example, a hypothetical example, could be the change of demands when it comes to shortfall in supply in particular states or in times of a crisis, in times of emergency, be it fiscal emergency or be it an emergency keeping in mind the national security, when certain commodities need to be regulated. That is why we have the Essential Commodities Act as well, which is often brought into place to ensure that there is equitable distribution of products that are required by the masses. Thank you.